Good evening, ladies and gentlemen. Welcome to TechGeek webinars, our endeavor to empower techies. We believe that sharing of knowledge is the key of enhancing our performances and for our growth as professionals. With this principle in mind, TechGeek has initiated a series of webinars conducted by industry experts to give a crisp insight of various domains. Topic for today's session is intellectual property and its growing significance to tech startups and IT companies. We are delighted to have Mr. Tarun Khurana, partner and patent attorney at Khurana & Khurana Advocates and IP Attorneys with us today. Tarun has over 9 years of experience in a broad range of intellectual property subject matters. He has executed numerous assignments related to exercises of patent portfolio creation, protection, valuation and commercialization for corporates ranging from small startups to Fortune 5 companies. Tarun focuses on patent preparation, prosecution, and litigation opinions for computer-implemented electronics and mechanical subject matters. Gentlemen, this presentation will continue for next 45 minutes and we'll take your questions after the presentation. In the meanwhile, you can post your queries through the chat pane available in the webinar software. Without further ado, I introduce you to our guest speaker, Mr. Tarun.
Hello.
Yes, Mr. Tarun, we can hear you. Can you hear me?
I hope I'm audible.
Yeah, you're audible. Your screen is not visible.
Excellent. So is it better now?
Yeah. Where are the? Yes, we can see your screen now. Please go
Wonderful.
ahead.
Can I start?
Yeah. Please go ahead.
All right. Perfect. Thank you. Now, a very good evening to everybody. Thank you so much, first of all, for coming down for the session for an hour and 15 minutes. The session, as I said, typically be focusing on intellectual property rights. It will be a basic session, which will take it forward into more complexities as we go forward. On the 17th, which is the next session of copyright. And so this session was largely be focused only on the brief overview of intellectual property and what they are, how they're protected, and issues related thereto. Now, without further delay, I'll start off with my presentation, and I'll try and finish it up within about an hour's time. I'll be very happy to take whatever questions that will come down in between, and the questions could directly be posted down to me, and then I can take them on as and when they do come down to me. All right. So agenda for today would typically be to introduce TRIPS, which is trade related.
Sorry to disturb you, Mr. Tarun. Sorry to disturb you. Actually, there's a break in your voice. Can you be like very near to the mic either?
I'm actually very near to the mic.
Okay, because actually we are facing some kind of distortion in between.
Okay, is it better now? A little better?
Yeah, it is. Right.
Okay. So
thank you.
Carry on.
Interrupt
me in case you find any further problem again.
Sure, definitely. Thank you.
Excellent. So the focus would be on TRIPS, what intellectual property rights are, what are the types of IPs that are available to the Indian, creative companies, or as I might call it, startups or R&D houses. What are the relevance to startups and software companies is what I'll be focusing on more as and when we go into the deep of intellectual property rights, and then we can have questions as and when they do come down to me. This is IP basically came down from the World Trade Organization. The mission of which was to bring down the trade barriers and make it effective for different countries to coordinate and communicate with each other as regards the trade of goods and services are concerned. And that was one of the reasons why TRIPS was a part of the WTO, because there was a lot of difference in terms of what different companies or countries typically had. Rights as far as intellectual property are concerned, what their trades are, what are the level of protections. And because of this huge disparity, there was a need for a guideline which was supposed to outlay something which was common between all the countries and that every country had to abide by. And that was the mission of TRIPS, and that was one of the organizations that WTO was commanding at that point in time. So WTO's mission, as I said, was basically to administer different trade agreements, making sure that all the disputes are settled at a common place and there is no biasness as far as any kind of dispute resolution mechanism is concerned. TRIPS had set out a minimum standard for intellectual property. There were different IPs that were protected all across different countries, and there was a need to lay down a common benchmark for all countries to follow. And till the time all the countries were following that benchmark, it was perfectly all right if they even did something over and above what was the minimum guideline that was primarily set out. Having said that, there was definitely a linkage between intellectual property, because every kind of monopolies and new drugs which were being created, there was a monopoly as far as patents are concerned in those drugs in certain countries. The time period for which those patents were given, what kinds of patents would be given for product patents or for process patents and so on. So there was a strong linkage between the kind of monopoly that companies or countries gained as far as their trade is concerned, and which had a lot of impact from the IP that those products or services were having within those countries itself. Coming on TRIPS again, it was criticized for not considering the needs of developing countries, because, for example, in the US, there were a lot of product patents which were critically being granted all throughout, and because of product patents, a lot of monopoly was being granted as far as the products are concerned over high blockbuster drugs, and which was something that could not be granted in India because of the public health and public issues. And therefore, there were certain needs for criticism that were granted and which were being made to ensure that the developing countries do not suffer because of high level of guidelines which are set. And therefore, there was a 10-year period which was given, which was under the Doha Declaration, and because of a lot of other declarations and movements of the WHA and the public health movements.
Hello, Mr. Tarun, sorry to interrupt. Can you please speak down a bit slow, because your voice is breaking and we're not able to hear you clearly.
All right, I will go slowly.
Yeah.
Sure. All right. So in summary, what I was basically saying is that the developing countries were given a special consideration of 10 years to comply with the TRIPS, and since from 1995 to 2005, they were given 10 years to comply with all the policies that were laid down by TRIPS, so that within those 10 years, all the developing countries would come to a common benchmark which was set, and there would be product patents, there would be patents on medical devices, on diagnostic methods, and so on and so forth. So depending on whatever baselines or guidelines were basically being set, 10 years were given to the developing nations to comply with those minimum guidelines and come to a level so that all the countries which were compliant or part of WTO are in the same embodiment itself. I will now come down to what intellectual properties basically are, how they are different from intellectual capital, and what is the difference between intangible assets. Now, this chart that we can see is the division of the capital of Nike. If we have a look at this presentation or the figure that is there, we can see that 75% of the complete value or the capital that Nike holds is in the form of intellectual capital. So what I mean by intellectual capital would typically be that in case we do make a shoe, which is typically probably being made in one small part of India, maybe in Punjab, and it's only because of the tick mark or the sign that Nike has is because of which it is able to command so much of a costing. Otherwise, as far as the production of goods is concerned, that shoe itself is not costing more than 200 or 300 rupees. The reason why Nike is able to command maybe 2,500 rupees additionally over and above the value of the active manufacturing cost of the shoe is because of intellectual capital which is installed in the tick mark, or which is the signage of Nike. So, and this is not something which is absolutely peculiar or specific to the Indian or any other specific balance sheet of any specific company, and if you analyze the balance sheet, if you have the number of shares and the number of value of that share, so if there are 30,000 outstanding shares, if the value of each share is 50 rupees, and you multiply that to compute the total capital, then you will have an actual monetary value as far as the share market price is concerned. The difference between the entire set of value is completely intellectual property, and it could either be in the form of intellectual capital or could be in the form of intellectual property. Now, intellectual property could include patents, could include trademarks, designs, copyright, geographical indications, and so on and so forth. And intellectual capital is a combination of intellectual property and intangible assets. So, for example, for a company like Infosys, their fixed or the tangible assets would be very limited when compared to the intangible assets. The intellectual property itself might be very limited as far as the total volume is concerned, but the intangible asset lies in the human capital. It's because of those 10,000 plus people that work in Infosys, is because of which it is able to command such a huge capital or the revenue, and in terms of the total capitalization of the company is concerned. So the point to take home is that intellectual capital, first of all, is a combination of intellectual property and intangible assets. And intellectual property, we will discuss them later on, but intangible assets could include human capital, enterprise knowledge, enterprise innovation, any kind of a relationship, which is not a creative bent of mind per se. So it's not a creation of the creativity of a person, but it lies in the human or the resources that you have to work as far as the company is concerned. So any services company, be it a software services or a financial services company, would have very small portion, as probably the figure explained, about 9 to 10% as a tangible asset in the form of the shares or the inventories and so on and so forth. But over about 90% of their entire valuation would be revolving around either IP or the intangible assets. And in most companies, services companies, it would be in the form of intangible assets. Okay, we come down to what intellectual property is. Now, an IP could be a product or of any kind of a human intellect. It could be an idea, it could be an expression, it could be a unique name which eventually gets translated to a brand or a business method or a chemical formula. Anything which is an intellect, which reflects or is a product or an outcome of an intellect is what an intellectual property is. What are you protecting? We are protecting patents, we are protecting copyrights, trademarks, geographical indications, designs, and trade secrets. So all these six are six types of intellectual. All of them are independent of each other. All of them are protected in different manners, and they protect different aspects of your creativity. We will go through each one of them one by one, and then try and understand of what each intellectual property would mean and how they are different from other intellectual properties that we've already discussed about. The clarity remains. I will go back again because post this we will be discussing each intellectual property one by one. But just to again revise what we did understand. So intellectual capital is a combination of intellectual property and intangible assets. And intangible assets would be anything which relates to humans as far as the resources are concerned or their intellect is concerned. But IP would always be an outcome. It would always be a product at the end of the day of the human intellect itself. And combining both of these is when we get intellectual capital. Alright, so we start with the trademark and service marks. Now, trademark could be anything. It could be any kind of a signage, it could be any kind of representation of a logo or device, or any kind of a representation which identifies the source or the goods or services from which it is coming. So as we can discuss about Nike, the trademark that they have is their signage, and the reason why they command so much of it, like the entire costing, or why their shoes are expensive, is completely driven by the signage. It's completely driven by the trademark that they command, which is valued in billions of dollars when it actually gets sold off, or when it actually gets valued. Same is the case with Google. another company which is exactly having the same search engine as far as the concept is concerned or as far as the technology is concerned, but they do not have a name, the valuation would be not even a percentage or a fraction of what Google would command at this point in time. So the point to take home is that trademarks or service marks or any kind of representation could be a logo, it could be a song, it could be a jingle, which would represent the origin or the quality of certain goods or services. Trademarks are protected world over, and all intellectual properties are territorial rights. And when I say they're territorial rights, so they will only be protected in the countries in which you file for them or you get them protected, except copyright, which we will come down to later. But trademarks, for example, if you file for a trademark application only in India for a company or a product that you have started off with, it will only be protected in India. And if somebody starts using the same product or technology or same brand, as I might call it, in the US, then we will not be able to do anything to it unless and until we do have our own mark registered there. The rights of a trademark last indefinitely. They can be renewed after every 10 years. So there is no stopping by still when the company or the brand is being used. There is no stopping by. They can renew it at any point in time. The components of a trademark could be colors, they could be sounds, they could be design, slogans, logos, as I said. So it could actually be anything and everything in totality. Trademark, again, so they act as a connector between the goods and services. So there could be any product coming down from Kodak, you would know it would be a camera or it could be an electronic device, which would typically be in the digital media space, more often than not. A trademark can be an adjective, not as a noun. It could potentially be a noun. It all depends on how do we try and protect it. But the point to take home is that there are few types of trademarks that we try and get registered. I will come down to this slide later. But there are certain trademarks which are suggestive. Suggestive trademarks are trademarks which suggest or which are inherently telling us about the origin or the product that they pertain to. Now, for example, if we have mother dairy, now if we have any word which probably would say the word dairy, it would obviously be related to a milk product more often than not. Any buy tickets or book my show, these are all trademarks which, even though are very strong trademarks from the valuation perspective, are trademarks which are suggestive. So they tell us about the goods or services that they pertain to. At the same time, if there are trademarks which are absolutely distinctive or differentiated and are coined words, as we call it, for example, Xerox. Now, Xerox does not inherently have a specific meaning in totality. It is a coined word by the company which had started it. And for example, marks like kerosene. Kerosene again is become a household name. It has now become a generic mark. But when it started off with, it was basically a noun, and it was a mark which was coined. It did not have an inherent or a suggestive meaning in totality. What are the kinds of infringement actions that can be taken? So in case, as I did say, trademarks are completely territorial rights. So in case somebody does start using an unauthorizedly a trademark which you have already filed for or you think you possess, then these are the three damages that you could typically get as a grant for. The injunction would typically be a stop on the other party to stop using or restrain from using your own mark. So if you are the trademark holder, which you already have a registered trademark, and then other companies start using your trademark, then in that particular case, you can seek for an injunction and ask that company to stop using that mark immediately. And it could be a civil case that you would typically have to file. You could seek damages from whatever accounts of profits. So the damages would be compensatory damages or could be punitive damages. And these are damages that you would have to ask from the court of law on the amount of profit that you think the other company would have made by using your own trademark. In addition, we do have two different representations for trademark which a lot of times are not very clear to people. Trademark is sometimes represented as R with a circle. Karan, the circle represents a registered trademark which is registered with the trademark office of that particular country. TM on the other hand suggests that the mark is not registered. So it's a trademark which has been applied for. So, for example, if Haldiram is a company which was started in 1965, it did not file for a trademark application until 1995. And in that particular case, all throughout this time, Haldiram was using TM. So the point to take home is that in case your mark is registered with the Government of India with the Trademark Office, you can start using R. Else, if you've not filed for a trademark application or it is still under processing, TM is the right representation for this entire mark that you would typically be using. There are certain case studies that we wanted to share across with you. Now, the point third of this particular presentation says that you should try and enforce your mark on as collectively or coordinatively as possible so that the mark does not become generic in any sense. Now, a generic mark is a mark like fridge. A fridge was not intended, it did not have a suggestive meaning. It was purely a coined term, and it was a trademark which was registered by a company. And eventually, everybody started calling every refrigerator as a fridge, and then the entire word refrigerator itself became a generic word in totality. Similar was the case with Xerox. Now, the problem with Xerox is that Xerox started off as a company and it had its own set of products. But eventually, over a period of time, the mark became so generic that whenever people used to go to buy a printer or a machine for photocopy, they would say that, I want to buy a Xerox machine. And any other product, which would be maybe a Canon product, also used to be sold as if somebody was asking for a Xerox product. So Xerox became connotated or became equated to a photocopying machine, and everybody started calling it as a Xerox. So the problem with excessive use of such a word is that if you do not enforce the use of the trademark properly with all the people who are stakeholders who are using that mark, it eventually becomes a generic mark, and people start using it in and out. And after a certain point of which, if this is not enforced, the mark becomes generic, and you lose your entire right over the mark as well. There are certain cases that have been listed down, one of which is called as Gucci versus Matrix Cellular. This was the case that we handled. So the point in the summary of this case was that Matrix Cellular had basically made or given an advertisement in the newspaper promoting their own SIM cards for sale, and the objective of using Gucci was that the advertisement was such that it connotated a meaning wherein in case you start using the SIM cards which are given by Matrix Cellular, then you save so much of money that you can actually buy a Gucci product. Now, the intent of Matrix Cellular in this particular case was absolutely not bad. The intent was not a problem. The problem here was that use of a mark, which was a brand like Gucci without any prior authorization or approval, and which was a mark which is very well known all throughout, was something that was absolutely not acceptable because there was no authorization taken before the use. So the trademark gives you a right that these are products which are connotated with my own mark, and if somebody starts using my own mark without any kind of an approval from my own side and explicit authorization, then it constitutes or amounts to passing off. So passing off is a right which the trademark holder has, wherein under the passing off he can start an infringement action or a passing off action against the concerned opposite party and say that this company without my own seek approval started using my mark to promote their own goods or to promote the same set of goods that I own as well. Post trademark, we do have copyrights. Copyrights protect an expression or an idea. An expression would obviously be any kind of an expression. It could be a literal expression or it could be a written down expression, but it cannot be a verbal or a thought of expression. Now, what we mean by that is that if you have thought of an idea of making a movie with a particular script and you tell it to another person and he makes a movie out of it, actually speaking, then he is not infringing on any of your copyright because you had not expressed it in any manner to anybody. So you had not expressed it in a piece of a paper by writing down the script, but you had actually had an idea which you shared and for which you do not hold a copyright because there was no expression, literally speaking. Copyright encourages efforts, creative efforts by securing exclusive right to reproduce works and derivative income from there on. So what we mean by derivative is that in case somebody has written down a book or somebody has written down a software code for which he does have a copyright. Now, in case another person uses the same code and absolutely the same logic in the sequence, but in a different platform altogether, and that the copyright holder is still the owner of that work as well, because that other work is only in a different format. It's a derivative of the same work. So if, for example, the complete coding has happened in Java and the complete source code that we have is in Java, but then the other company starts using exactly the same flow of sequence as far as the programming is concerned, but makes it in .NET source code or maybe in another platform, then he will still be infringing on the copyright of the original author. Same is the case with books. So if somebody writes down a book today and protects it as a copyright, he will have the right or the authorization to protect anybody else from making any derivative. So nobody can make a movie out of reading the same book, because any derivative work from the same original work would still be considered as copyright of the original writer itself. Copyrights are not rights that need to be protected. They are not rights that you have to register with the Copyright Office. The moment you put it down on paper and have it in the form of an expression, that is sufficient enough for somebody to have a copyright. We do not actually have to go down to the Copyright Office and get that protected. There is no explicit registration which is allowed, as I said, and the life of a copyright is 60 years post the death of the author. Copyright is created automatically once an original work has begun and it has been fixed in a tangible medium. As I said, so it has to be in a tangible. I do have a question. The Copyright Office is in Delhi. The question for everybody was that where does one register copyright? So copyrights are registered in the Delhi Copyright Office. It's near Cannot Place, and that's the only office that we have to go to for registration of the copyright. Now, because this question has come down, what I would also like to mention is that copyrights for softwares need not be registered in totality. So one does not need to give the entire source code as far as the copyright registration is concerned. Even if it's at a first or the second level of abstraction, wherein we mention all the data structures and the sequence of flow of the instructions, rather than writing the entire for or the while loop as well, we are still in the mode that we can go to the Copyright Office and seek protection for. The more we write down, the more detailed we go into the copyright, the limited our protection becomes. Because then we are trying to go into the literal protection. So if we actually do write the for and the while loop as well, and exactly the same sequence somebody else implements, the same step, the same functional step somebody else implements with another logic, then he will not be infringing on the copyright that we possess. So it's extremely important to make sure that we are having the copyright in the right sequence. All right. So designs, this is the third intellectual property that we are talking about. Designs are protecting any new and original feature or shape or configuration pattern, anything that typically is the core area here to understand is that design only protects the aesthetic look of an intellectual or of a product. So it does not protect the functionality of the product. If somebody develops or makes the structure of Ferrari in such a way that it is able to speed to maybe 10% higher the maximum speed level that it is right now, then that design of Ferrari would not be protected under the Design Act. It could come under the patent side of things because it would typically be more of an inventive concept, but it would not be designed because this design is not an aesthetic design per se. It could be construed in one embodiment as an aesthetic design, but it eventually impacts or improves the functionality. And sooner the word functionality gets associated with a design, it becomes the subject matter of patent. It does protect, it becomes a new technology or an invention or an improvement in the existing functionality or in all totality. So design, as I said, completely have to be judged by eye and nothing else in totality. Exclusive right to reproduce the article. It has a term of 15 years. It is initially given a grant for 10 years, and then 5 years more is where we can ask for. Post that, we have the exclusive right to stop anybody from reproducing the article. So what this means that if somebody makes exactly the same kind of a shape of a bottle or same kind of a shape of the product, if he would not be infringing, he might or might not be infringing on the other IPs, but he would definitely be focusing if the design gets registered. Now, design is, along with patent, is an IP that needs to be protected at all points in time. What I mean by this is that unlike copyrights or trademarks, which are to the discretion of the owner, so for the copyrights or for trademarks, one might not go to the trademark or the copyright office to get it registered, because sooner you've expressed it in the piece of a paper, you have the copyright inherently with you. Same is the case with trademarks. If you have been using it for a long time, like Haldiram, you need not actually have to go down to the trademark office and get it registered. The only advantage that we have to go to the trademark or the copyright office is that we have a legal date associated with all that intellectual property. Now, what I mean by the legal date is that at least if we do write down a book and we go to the copyright office and file it, the advantage here is that when we file it, we do have the application number along with the date. So if there is a dispute going forward, our entire effort of justifying the expression date or the date the copyright was created gets saved, because we've already filed the expression that we had created in the copyright office. But in case of design and in case of patents, we have to register it, unless it's not an implicit right that you just think of a design and you start making it and you say later on that I have a design already in it. So I hope I'm able to clarify the difference from a statutory perspective. Designs are the disclosure diagrams, so we basically have to give the representations of the photographs of the design that we have thought about from different views, and then it typically takes about 6 months of time for the design application to be registered. As far as copyrights are concerned, copyright is all dependent, as far as the time it takes for registration is dependent on the work that we are protecting. So in case if it's a software work, it takes close to about 6 to 8 months for us to get a copyright registration certificate. But if it's for other literary works or for artistic work, it could take much longer than that as well. As far as trademarks are concerned, trademarks typically, if they are not objected to by the trademark office, take about approximately 1 year for the registration acceptance to come down to us, or the trademark office acceptance. But in case the mark gets objected to and eventually also gets opposed by another third party, and in that case the period gets extended to 3.5 years as well. Trade secrets is another type of intellectual property. Trade secrets are those intellectual properties that are not known to competitors. The best example for trade secrets would be Coca-Cola. Now, the entire formula or the compound by which Coca-Cola is primarily made is kept as a trade secret. Now, the reason why it was kept as a trade secret and not as a patent is that a patent is valid only for 20 years. So it is valid only for 20 years from the date of filing for that application. As far as trade secrets are concerned, there is no time period. So till the time you can maintain it absolutely thoroughly as a secret, the entire protection goes forward till that time, till that period of time. So the point to take home is that in case of patents, once you've already disclosed your complete idea, you get a limited protection for 20 years, after which the entire public around yourself is able to practice that invention, can make that invention without seeking any kind of clarification or seeking any kind of approvals from the patentee. But in case of trade secrets, because it is kept as a secret, nobody knows about it, and the time of protection is for the entire period of lifetime. But in the caveat here is that in case somebody does come to know about it, then he can start practicing, and it becomes very difficult to defend the trade secret. Geographical indication is another type of intellectual property. What happens in geographical indication is that I do have another question. I just think that I'll just read this question this way. The question says that suppose a person is offering services with respect to medical issues through web, then would it be advisable to register the website as a service mark? Now, Mr. Higde, in case your question is by website you mean the domain name, yes, it would definitely be advisable to register, to try and register the trademark, the website domain name as the trademark as well. Absolutely. It would be very advisable because there are a lot of domain names which do get registered, and the advantage of having domain name as a trademark is that in case there is a slight change in for example, if you have a website which is called as abebooks.com, and if somebody tomorrow starts making, and if you only maintain it as a domain name, and if you do not file it as a trademark, then if somebody goes ahead and does a who and tries to protect ABE book with the S not being there, then he would get the registration and start practicing the same services which might be on online book transactions. So, and there will be nobody stopping him, because nobody can stop you from registration of a domain name unless and until we have a domain name resolution dispute which is filed, and then the entire case goes on in the dispute resolution, the domain name dispute resolution mechanisms. But in case we file abebooks.com as the domain name, as a trademark, then any small or possible variation of that, which could typically be abedbooks.com or abebook.com, all those variants would be considered as passing of actions against your own domain name. So it would definitely be advisable. It would definitely be advisable to register the domain name as a trademark as well, because it does accord you a larger protection. The cost of filing a trademark application is extremely low. The official cost of filing it is approximately about 3,500 rupees. The attorney fees would obviously be dependent, but it would typically be generally in the range of 2,500 to 5,000 rupees. So in about 8,500 or 9,000 rupees, you are able to file for a trademark application in one place for one set of goods and or services. So it does make a lot of sense. There's another question: can copyright be transferred from the author to the owner to another party? Absolutely, and it can also be done at the time of filing of the copyright itself. So while you're filing the Form 4 or filing the copyright application, as I might call it, we surely can go ahead and file the application in the name of the applicant, mentioning that the author of that work is another person who is an individual entity. So in case we do write down the source code in which there were 5 people in that team, all 5 of them would be authors, and the applicant of that copyright would be the company for which they work for. And along with this copyright application, it would also be advisable to send and file a cross application, which is the assignment deed or the letter of engagement or the letter of employment that you might be having from the company. It says that all intellectual properties that are developed by the employees of that organization would automatically be assigned to the applicant or to the company itself. So if that assignment or the letter of employment can be taken and that cross can be submitted, it absolutely is not a problem to go ahead and file it like that. There is another question: can facts, databases, and compilation be copyrighted? Absolutely. You can write down all the data, and the database could typically be the schemas, or it could either be not the data per se, but actually that expression of that data within the database in terms of what tables, what format have we protected it in, we can definitely go ahead and file for a copyright for that as well. Geographical indication, as I said, is another intellectual property which gives us an impression of where the goods or those products are coming from. So it gives us an origin or a sense of origin of that good, where the product is coming from. For example, Darjeeling tea is a geographical indication, and it is a right accorded to the Darjeeling Tea Association that only the members of that association and the tea that they produce would be called as Darjeeling tea. In case somebody in Mumbai has a tea plant near about Mumbai itself and is able to make tea, and he cannot name that tea as Darjeeling tea because there are certain environmental, there are certain geographical, there are certain aspects as related to the soil, the conditions, the temperature, the pressure, and so on and so forth, which make a specific kind of a flavor or sense of a smell or any other kind of an attribute which distinguishes Darjeeling tea that is made from Darjeeling and tea which are made from other areas. Same is the case for Banarasi sari. Same is the case for Tirupati laddu, because every product has or gives a sense of the origin where it is coming from, and that is distinguished and divided. Geographical indications are never recorded to individuals. They are always recorded not even to corporate but to associations only. So there would be an association which would have a certain set of companies, and only members of that association can use the geographical indication which has been awarded to it. All right, so we come down to the most important and interesting session, the slides, which would now be talking completely on patents. Now, the fundamental difference I'll start off with between patents and copyrights are that patents protect concepts, they protect functionality, they protect the implementation or the inventions, they protect ideas, as I might call it as well. On the other hand, copyrights are literal expressions. So if, for example, we implement a functionality which would typically, for example, go to meeting. If somebody implements this functionality on a particular way or to a particular source code in a particular level of logic, that complete source code can be implemented and can be protected as a copyright. Either he files it or he does not file it. However, in case somebody implements exactly the same functionality of GoToMeeting, the way it works, the way it conducts the meeting, the way people add different, the way we show our screens and so on and so forth. Now, all these functionalities that somebody else also implements, but implements it in a different logic altogether, through a different source code. When I say the source code, I mean the flow of that source code in terms of what was implemented and what kind of conditions were employed therein and so on and so forth. So, if somebody implements the same thing by another logic, then in that particular case he will not be infringing on the copyright, because the copyright is on the expression or on the format of the source code which has been written in a completely different manner. But what patent would do is that patent on the other hand would protect functionality. So irrespective of what source code do we write it in, what logic do we implement in implementing it at the source code level, if the functionality of the entire system or the method is the same, then in that case it is absolutely protectable or would be covered as far as the scope of the patent is concerned. All right. So, what is a patent? So, patent is basically a grant of certain exclusive rights which are given by the government of India to one or more individuals or applicants for a fixed period of time. That's extremely important, because for 20 years from the date of filing of that patent application, in exchange for a disclosure. So, what you get protection for is the disclosure that you make of the invention. So, I'll be taking one small example all throughout the case studies that we'll be speaking here. Now, what I mean by disclosure is that if, for example, somebody has invented a laptop which instead of getting charged by lithium batteries gets charged by solar cells. Now, he would have to disclose how such a laptop would work in terms of how the solar cells, what size would they be, how would technically they be placed within the laptop, how would they get charged, how would they get discharged, and how would they supply, how would they act as a battery, as I did say, as far as the power source is concerned with the laptop. Now, once we do understand this, we have to explain it in a manner so that the person reading it, who is typically the examiner, is able to understand the invention and would be able to understand what the inventive concept is. In case he thinks that there is nothing which is there existing in the public domain at that point in time which talks about the same concept, the invention becomes patentable. We will come down to the exact conditions which need to be fulfilled for getting a patent. But more importantly, the point to take home is that there has to be a certain disclosure that needs to be made by the inventors. And if that disclosure bypasses a certain level of examination standards for patentability, then the Government of India for 20 years from the date of filing for that application gives an exclusive right to the patentee to stop anybody else from using or practicing that invention or that concept, as I would call it. And that is completely independent of what and how did we actually protect, how did we actually implement it from a source code level perspective. It's more the concept level. It's a techno-legal document. It rewards disclosure, so there is no point in keeping any secret in any sense. Whatever you disclose is only for what you get protection. So in case you only protect or disclose a partial set of disclosure, or you only disclose 75% of what your invention is. So for example, if you've probably made a formulation or a drug or any kind of a composition for improving or curing diabetes, for example, and in case you do not mention all the components thereof, then what you get protection for is only for those components. And if somebody else starts using the same subset of the components which are protected, a small subset of it, but uses something that you have not already disclosed about, he will not be infringing on your patent. We will come on to these details once we go forward. Patent, like a design, like a trademark, is a territorial right. So we only get protected in the countries in which we have filed for the patent application. Okay. Now, potential commercial products. So the products would typically be methods of making and using the product. So one method could be, for example, a method for going from an X location to a Y location using a certain algorithm. So for example, the algorithm which is there as part of the GPS devices or the GPRS, or maybe another method for ensuring that the touchscreen devices that we typically use are working in the proper format as far as the sensing electrodes that are there inbuilt, they are functioning in the same manner. So how we press a certain specific location on the entire touchscreen, how that enables the functionality that we need to protect. All these are part of inventive steps, and all these are aspects for which we do get patent protection for. They could be methods, they could be systems that could utilize companies' products, they could be microprocessors, they could be systems or methods that run within the microprocessors to achieve a certain functionality like memory optimization, the way we store data in the memory, and so on and so forth. Patents, as we did discuss, the mandate of getting a patent is to get an exclusive right to stop others or any third party to use the particular patent. I have another question. Can the same software qualify for both copyright and patent protection? Now, Mr. Padhai has asked this question, and you've got to understand that both of them are completely independent IPs from each other. In case you, for example, develop a software for implementing an X functionality, the source code that you develop can always be going forward, and you can always go forward and get that copyrighted. Nobody can stop it. At the same time, if the functionality that you have for that software is, for example, qualifying for the patentability criteria like novelty and non-obviousness and utility, which we'll come down to later, then in that particular case, we absolutely can file for that software the copyright as well as the patent application is concerned. The point to take home is that copyright application can be filed at any point in time for any software. There is no denial about it. Any software we can file a copyright application till the time the piece for which we are filing a copyright is not a piece that we picked up, or it's not, that's a piece that we have written down and not an existing piece on the net or any piece that you've taken up in another copyrighted source code, as I might call it, or a piece of source code. The point to take home is, again, as far as patents are concerned, on the other hand, if they do qualify at the same time for patentability, as far as the patentability criteria are concerned, if they are novel, if they are non-obvious, and as far as if they do have a certain utility, then absolutely the same product which for which the copyright for the source code has been filed can absolutely be filed as far as a patent application is concerned as well. I do have another question. What happens if an invention is made public before a patent application is filed? So patents are given, the entire system of patent depends on the first to file kind of a mandate. So if the patent, when you file for it, I'll come down to it later as well, it has to surpass, or it has to bypass 3 conditions. I'll see if it's in the next slide. I'll come down to, I think it would still be there. But the first and the primary condition for which we do get a patent always is that the patent application has to bypass the novelty standard. What I mean by the novelty standard is that if the day we file for the patent application, on that very day, we have to ensure that there is nothing in the public domain which talks about the same concept. This is an absolute Bible all across the globe. So there has to be absolute novelty. The day we file for a patent application, if there is anything in the public domain, any literature, any other patent application, any journal, any web page which talks about the same concept, it would be held as a non-patentable subject matter because it would be construed as non-novel. And it is something which is done at an absolute level. So if an Indian company, for example, if Infosys tomorrow goes ahead and files for a patent application, which they do quite regularly as well, and if somebody has talked about or disclosed the same concept on a web page or in another product in the US, and if that product is also in the public domain, or if that information is also in public domain in any format, in that case, that publication would be used as against hinting out the novelty of this invention. And this invention would be held as non-novel because the same prior art was already existing outside India. So it has to be an absolute worldwide novelty on the date of your filing. So if your invention is made public before the patent application is filed, your patent application, even if you do file it, would be held as non-novel when it actually gets examined. The second standard that a patent application needs to surpass for getting the patent granted is that it has to be non-obvious to a person who is skilled in the art, ordinarily skilled in the art. Now what I mean by that is that in case somebody has made a laptop, as I did say, with solar cells, hypothetically, now in case laptops are not supposed to function till now, they have not been used with solar cells or with solar batteries, then it's a novel concept. So nobody can destroy the novelty because there is no public document available right now which says, or which has, and this is completely a hypothetical situation. Assuming that there is no public information which says about this kind of a concept, then it bypasses the novelty rejection. It bypasses the novelty rejection, but it would then be under the umbrella of whether this was something which was non-obvious to a person who was ordinarily skilled in the art. Now what I mean by non-obvious is that solar cells were already existing. They were already well known, they were being used in combination with a lot of other products, and laptops obviously were there as well. So was combining both of these two technologies which were already known, something which was obvious to a person who was in that particular art, which could be a person who is dealing either with the technologies related to laptops or technologies related to hardware devices, electronic hardware devices, any person in that particular domain. And if it is established that both these things were already known and combination of thereof was something which was absolutely obvious to any other person who was known in the art, then even though that invention or that product or that concept is novel, it would still be considered as non-patentable because at the end of the day, it was something that was obvious to a person skilled in the art. Obviousness is something which is subjective. There is no novelty is something which is very objective, because if there is one document which talks about exactly the same concept, then in that case if the novelty is destroyed. But in case of obviousness, it is not a straightforward question, because it relates to the person skilled in the art. Now, the defense from an applicant who's made such a laptop would be that if the laptop and the solar cells were known quite well, then why till date nobody has made them? Or why have there were so many technical difficulties in making them of a particular size and making them embedded in a laptop such that they start working properly and have a beautiful life size and so on and so forth. So there are defenses that are made from both the ends. So the examiner of a patent application would try and oppose that application saying that it is obvious, and then there will be certain defenses from the applicant side saying that why was there such an important, why was such a device not available? These were the technical barriers or technical difficulties that we had faced in making this invention, and therefore it is not obvious to a person skilled in the art. I have another question. It says, what happens if I want to use or acquire a previously copyrighted name for my software application? What happens if I want to use or acquire a previously copyrighted name? Now, I will have to ask Aditya to confirm me whether he means does he mean copyrighted name or the name which is trademark. So unless and until, because copyrighted name would be something which would be not a very common thing to do. Nobody would want to copyright a name. So I have to check. So if I'll try and answer your question, understanding and assuming that what you meant was a trademark. If I want to use or acquire a previously copyrighted name for my software application, so absolutely. So in case the trademark application has been granted in my own name, and if you want to use my own trademark, you can absolutely seek my permission and either buy the trademark along with the brand value that it is associated with, or get a license from me on an exclusive or a non-exclusive basis, and so on and so forth. So there can always be assignments that need to be done with prior approval and authentication and authorization with the original owner. The same is the case that also is true for copyright applications. So if Google is an owner of a certain copyright for a certain specific code set on a small algorithm of how to maybe optimize keyword generation or predictive keyword generation as far as when we do searches is concerned, and you want to use the same source code which is already copyrighted by Google, we will have to take and seek permission, and it is completely at their own discretion whether they do allow or do not allow such kind of an assignment to take place. So if they do allow, they might expect certain consideration, but it is completely something which is possible. There's another question which says that if an independent third party develops a program for a company, this is where Mr. Upadhyay. So in case an independent third party develops, it is something which is completely driven by the agreement that the company has had with that third party. At any point in time, that agreement has to say that whatever intellectual property that does to get generated who would be the owner. In most cases, if it's an outsourcing activity, the company which is outsourcing that would make sure that all the intellectual property rights are with that company. So, but it's not something which is the Bible, and would be completely something which would be driven by the agreement that has been filed between the company and the third party. Another question: what is the punishment in the act for falsifying GI? Now, falsifying GI would typically be like, for example, somebody starts making Darjeeling tea in Bombay and starts selling it as Darjeeling tea. The action is punitive, or a civil damage can also be seeked. So you can always go to the Delhi High Court, depending on the kind of damages that you're seeking from that particular person. There would obviously be a restraint in the form of an injunction that can be taken against that company, and so the injunction gets granted, a civil damage or a civil suit can also be continued, and damages can be seeked from that company as far as any kind of falsification is concerned. The plaintiff in this particular case, or the petitioner in this particular case, would be the association and not any one particular company within that association. Okay. I think I've been able to answer most questions till now. And in case there's anything, please do let me know. So patents, as I said, the major objective is to stop others from practicing the invention. There are no rights in unclaimed subject matter. So in case you do not claim certain aspects of the invention, then anybody can start using it. Now, for example, what I mean is that in case your invention talks about a particular functionality or a patent application. Now, for example, if you are trying to connect your mobile device with some kind of a social media, and there are 4 or 5 different things that you want to do in it. For example, if you want to send messages through your social media directly to another person's mobile phone, then in that case, and if you want to, apart from the SMS, it will also include MMS, might include certain other information, any kind of an information. And in case you do not claim any one of those features, you disclose that it will protect 1, 2, 3, 4, 5 features, and if you do not claim the third feature, then anybody can start using the third feature without any kind of approval from your own end. So whatever you want to get protection for, you have to claim it. And when I mean claim is a certain portion of a patent application in which you categorize what your boundaries of the invention would be. So you have to dictate that this is what my protection is, and then this is what my protection is. And then there are 10 or 20 or 30 claims that you have to write down. Each of the claims would give you a certain level of protection. We will come down to it and we go forward with the presentation. Okay, so these are the 5 rights which are given to a patentee. The rights exclude the right of the patentee is to exclude others from making, using, selling, offering to sell, and importing the patented concept that you have. Again, it's being a territorial right. If I file of a patent application only in India and I do not file it within the statutory time of 12 months outside India, then in that case anybody in the US can copy, because it's a disclosure that we are making. So the same concept can be copied by any company anywhere outside India, and they can start making that, practicing that invention, and we cannot do anything to it at all. Patents versus copyrights. Now, patents and copyrights. So, as I did say, so patents protect functionality and copyrights protect expression. Patents are independent creation. Is not a defense, because it is completely dependent on what the functionality is, and it could be independent or it could be dependent on prior patent applications or functionalities that other people have already made. It is more difficult to avoid because it has a larger protection, and this is the reason that patents are much more effective than copyrights, because copyrights only protect what your expression is, and if somebody changes their expression even a little bit, it becomes subject matter of it becomes subjective of whether you will be able to enforce it or not. But on the other hand, patents protect functionality, so completely irrespective of what way we did express it in, we would always be protected for that functionality, irrespective of how we had implemented it as far as the software is concerned. It has long pendency. Copyrights are instantaneous, because the moment you write down, so you write down or you express your thoughts and processes, you get the copyright. Patents, because you file it, it gets examined and eventually gets granted. So the time period that you have for getting a patent is approximately about 3.5 to 4 years in India. It could be longer than that as well, but estimated approximate time is about 3.5 to 4 years from the date of registration. Now, till the time it does not get registered, I'm sorry, from the date of filing, it is about 3.5 to 4 years. And till the time it does not get registered, we can continue to use patent pending along with the application number to tell the public at large that it is a concept which you have already filed a patent application for. Copyrights are easier to register because it's mere an expression, and you just need to file it, in 6 to 8 months down the line you get a registration. So there are advantages with copyrights, but the biggest disadvantage with copyrights is that the level of protection is very low, because any small change in expression would be out of the protection boundary of the copyrights, whereas patents can be as broad as possible from your side. these are US. This is a sample US granted patent application, and we can probably go forward. And I can send across these things if desired. If somebody can email me as and when they will require this kind of information. Yes, so these were the 3 tests for patentability of an invention. We did discuss about 3 steps. Novelty is the first step, non-obvious step, and the use is the second step. So we have to ensure that the novelty is achieved by making sure that there is nothing in the public domain which is available across the globe before the date or at the time of the filing of the patent application. Non-obviousness, there has to be a technical advancement. It should not be a combination of 2 existing technologies, and it has to have an economic significance. Usefulness, it has to have a definite application, and it has to be consistent. So it's not that when we practice the same invention again and again, it gives you different results again and again. Then it would be objected under the useful criteria. This is the general procedure for getting a patent application granted. We file the patent application. It gets published after 18 months. The patent application, we have to give a request for examination within 48 months from the date of priority, which is the filing date as well, earliest filing date. Once we give the request for the examination within 6 months, according to the statute, we are issued the first examination report. This typically in practicality is about 1.5 years instead of 6 months. And once we have the examination report, which would have the objections or any kind of a comment that the examiner would have, we will have to satisfy him by giving appropriate responses within 12 months. So we have to give him a response sooner we get it, and in case he has further responses or further observations, he will have to comply with them as well and make sure that the entire case patent application gets granted within 12 months from the first examination report. What is the cost of patenting is a question that I've been asked. The cost of patenting depends largely on which all countries do we intend to file a patent application in. Now, and it also depends because the patent application is more of a techno-legal document. So the more complex the software is, the more complex the entire functionality is or the technology is, the larger would be the attorney fees largely for getting it protected, because then the patent application might itself run into 30, 35, maybe 40, 45 pages. It all depends on how simple or how complex the entire concept is. So it will be wrong for me to give you any figure right now, but I can surely give it once we understand, the level of protection as well as how complex the inventive technology that you've developed is. But largely, I think on an average, it would be safe to assume that 30 to 35,000 you can file a patent application in India, and then by the time it gets granted within India, the costing would be around 60 to 65,000 rupees. This is an average cost approximately till the time the patent gets granted, including the government fees as well. It could go up to a large extent, but it could come down as well, all depending on the attorney who is representing, but largely about 65, 70,000 rupees you should be able to get a patent granted in India. Now, claims, as I said, is a specific section of the Patent Act, is a specific section of the patent application which defines what the scope of the patent application is. It defines what the boundary of our protection would be, and this is the reason why they are the most important and fate deciding part of for any patent application for that matter. This time, I would also want to mention one thing quite clearly, that in India, under Section 3K of the Indian Patent Act, software applications are not granted patents, which are software per se. It is unstatutory in case we decide to go for a software application which has no involvement or impact on an hardware element on which it runs in any manner whatsoever. It will not be granted. So in case there is a simple software which predicts how the stock markets will behave tomorrow based on the information that we have today and on the historical information, there is no impact on the underlying hardware involved, and therefore it would be held as non-statutory under Section 3K. Any business method, any implementation of a business concept which does not involve any kind of a technical effect, and what we mean by technical effect is it has to impact the hardware in such a manner that the hardware behaves in a functionality that it usually does not function in. Now, for example, all embedded systems, any software which improves the memory allocation in the RAM or improves the retrieval of data from the memory or allocation of data to the memory are concepts which have or involve a significant proportion of hardware elements, or they do have a technical effect. But pure, simple software applications, which could basically be on social networking or applications in social media, or any kind of a software which is absolutely software in all senses and has no structural feature. When I say structural feature, it is almost equivalent to a hardware element. Then it would not be considered as a patentable subject matter, and that's something that most of the companies do not consider quite well, because even if they might get patent application granted in India, when the enforcement typically happens later on, it would not be held enforceable under Section 3K, because if it is established that there was no technical effect in that invention, and technical effect could be any effect which can be a tangible effect, which could be producible in a physical medium, then in that case, that software application per se would not be held. This is an exemplary claim by another company. So these are typically very complex expressions, as I might call it, of the protection. So most of the people who read such claims will never be able to understand and interpret what is the level of protection. So the broader the level of protection, the better it is for us, because then in that case we have a larger area to cover and keep our competitors out of space. Let me see if I have another question. No. So this is an apparatus claim which has certain encoding symbols and certain decoding symbols, and it has a keyboard that comprises of a number of keys. It could be a mobile keyboard, or it could be a normal computer, a PC keyboard, or any other keyboard, which is responsive to user activation to generate a sequence of said encoding symbols, and so on and so forth. So this is an exemplary apparatus claim. It's by an ergonomic company called Electronic Ergonomics based in Europe. Okay, relevance to startups, I think it's very important to have the right set of patents being granted, because a lot of these buyouts or leveraged buyouts or any kind of acquisition that typically happens, intellectual property is an important and integral part of evaluation of any company, and it's growing by the day. So any investor or any buyer of a particular company would always want to see what kind of technologies do they possess. And it's not only about the products, it's also about the kind of protection and the kind of monopoly that the company can gain over that product. And especially this is what the case is for most R&D companies. It's extremely important for them to make sure that the kind of patents that they get granted are very broad in protection. They are protected properly. They are claimed in the right sense of broadness, and they're not very restricted as far as their protection are concerned, and making sure that any competitor who might be wanting to claim the same domain would either take a license or be held as infringement, or be stopped from infringing from an infringement action, typically by use of injunctions and other tools which are available. Obviously, it is very important to make sure that the product which is covered or which is being protected by a patent, the patent application is not weak enough so that it can be designed around. Because if somebody is able to design around a particular invention, then he is not held as infringing on that particular patent. So it's extremely important to make sure that it's broad enough in complete protection standpoint, so that any small designing around or change in the structure or the functionality is still under the umbrella of your own patent application. I have a question. Other issues that need to be taken care of are confidentiality issues and implications, because especially from an intellectual property standpoint, in case somebody does, any employee of an organization does leak out or does put in the public media space any kind of a confidential information, which eventually could later on be maybe converted, which was a candidate for being converted into a patent application, then the entire information which was given on public media would be construed as a reference to make sure that this patent gets anticipated. So this patent would be knocked down completely in view of that. So every employee or every stakeholder has to ensure that there are very strict confidentiality clauses in the employee engagement and the agreements that are signed between the employers and the employees. There have to be dispute resolution mechanisms. It's extremely important, especially in case of outsourcing, wherein most of the time the venue of the dispute resolution is an arbitration, and in the country of the person who's outsourcing that work. So and it's very extremely important to ensure that if it's a neutral venue, it is actually much better than having a venue in the company's own original country, because it's much more convenient for them to take an action for a small thing or a small infringement action as well. But if it's a neutral location, it's equally difficult for the other party as well. Exit practices are extremely important because we have to mention what are the clauses under which you can exit from the agreement, what are the standards of practice, what are the clauses as far as the deadlines are concerned, or any other kind of benchmarks that might have been set out. So it's extremely important to have licensing terms are extremely important, because licensing terms might not be for the whole life of a patent, because the economic life of a patent might be only 7 to 8 years from the actual date of grant. And if that's the particular case, then the licensing agreements have to take, because if it's 5% for 20 years, it's maybe better to have 8% for the next 7 years, because after the 7 years, the entire technology would anyways get outdated. So that 5% would not make any sense. So it's maybe better to have a shorter economic period and a higher licensing revenue rather than doing it for the entire life of the patent application. This is just a case study. I think I'm reaching the time. So this was regarding Mango Technology, which had sold to their IPs and products around that IP to Qualcomm a few years back, and that was one of a very big achievement from an Indian R&D standpoint. And the reason why I mentioned this is that it was not the intellectual property that got licensed out, but it was a product that was built around that IP as a whole, which got licensed out. So it's extremely important to not only focus on building up and filing patents, but it's extremely important to develop products around that, so that companies who are looking at such products do not they might not want to have the bandwidth to develop those products. If they already have existing developed products and an IP backing them, it will be much more lucrative for them to consider it as a buyout option. It's extremely important to also do IP audits. A lot of times we do think that we have intellectual property and we've protected it in the right manner, but there will be a lot of concepts and inventive subject matters that would essentially not, we would have probably never thought of that algorithm being something that could be applied in multiple other products, and hence it's better to maybe file it as a patent application. There could also be cases wherein it might not be necessary to always file patents, because the caveat in filing patents is that we have to disclose the entire information in totality, and disclosure makes easier for other companies to understand what the inventiveness is and design around it and maybe improve on the same concept. But on the other hand, if we are developing a product which cannot be reverse engineered to understand what the code behind it is, then it might be making more sense to only keep it as a trade secret within the company and ensure that there is no leakage as far as the code is concerned. It does not come into the public domain and the product gets out. So and this would lengthen the product life cycle in totality. So I mean, it's important to have these deliberations in mind as well. These are certain more exemplary kind of technology. So on the left hand side, we have certain technology. On the mobile key space, predictive texting is what we call it. So it is a way of writing an SMS. So this was one constituent of how do we, what kind of, it was a method and a system for typing more effectively and more ergonomically. At the same time, on the bottom left-hand side, we have another technology for the method of route identification. So it is a method based on which a person could go from an X location to a Y location, based on different landmarks and how those landmarks could be used within that system to for getting one person who's not from that city from one location to another. So these are all concepts that you could that are patentable in all senses and which we typically want to file patents for. I have another question from Vandana. It says that can we file a patent for a framework which encapsulates several available products? Yes, absolutely. So it's again a very subjective question because we'll have to understand what are the products that we're talking about. But if all those products are already in public domain, and what we are only doing is combining all those products to make our own product, then in that particular sense it would not be considered. It would, as we did discuss, it will be considered as a novel concept. So it will bypass the novelty rejection, but it will still be considered very heavily against the obviousness. So till the time you can prove or you can argue against the fact of why it would not have been obvious for a person to combine or encapsulate those available products, it would not be held as a patentable subject matter. This was an RFID technology that typically was being used for identification, and on the right hand side is the corresponding system diagram relating to that. On the left hand side is the actual device that was being sold across. So it was a more enhanced RFID solution, which was specifically for laptop bags and making sure that everybody there is no identification system required if you do have these tags, which was a part of the employee badge itself. So this was technology around that concept. This was one of the largest litigations that have happened. US is more stringent on such patent litigation, and this was between Research in Motion and NTP, wherein NTP had a certain set of patents, and and RIM was making BlackBerry, so their email system was the heart of their entire mobile, and that still continues to be. And their email system was using certain algorithms for fetching and retrieving email, and through POP and SMTP and so on and so forth. And there were a lot of other patents on wireless email and RF antenna design as well. And NTP offered to they were using, and they were already patented by NTP. NTP licensed out wanted to license out the patents to them, and the offer was denied, and the infringement action was taken to the court. And NTP eventually got an injunction and $23.1 million as far as the settlement is concerned. But what happened at the end of the day was, because RIM could not function and their entire device, the mobile phone, was revolving around the same wireless email, and that patent was crucial, they had to have an out of the court settlement, and which amounted to the total value of approximately $612.5 million. So I mean, these are the kind of impacts from a monetary standpoint that intellectual property can have. And the objective of only talking about in this particular webinar was to communicate that it's not something that should be ignored at any point in time, and if adequate and properly filed patents are put across on the table, I'm sure it does increase the valuation of the company significantly. I am done with my query, with my session, and if there's any other questions or clarification that you would have, I'll be very happy to answer them as well. Bharat?
We are waiting for additional questions. We'll wait for 2 minutes. If anybody of you have any queries, you can please post in the chat pane.
There is a question that I have. I'll just take it. This question is from Mr. Hegde. IP portfolio management for startup. So it completely depends on what. I didn't completely understand the question, but you know, the point that I would want to make here is completely dependent on the kind of startup that you have, the kind of business that you are in, the business model that you have from a revenue generation standpoint. There need not be necessarily always for software companies the concept that would be eligible for filing patents. But if you have the copyrights, if you do have the right set of trademarks, and if you do have the concepts, even within those softwares, if you do think that there is something that from a functionality standpoint is completely significant, it's always advisable to discuss with the concerned patent attorney and ensure that if it's making certain sense, then it's always worth. It could be a very high value patent if it is something, if it relates to a functionality particularly which could go into multiple domains. If, for example, there's a lot of insurance products these days in the market, and if you develop a software tool which computes the age of a particular person, takes into consideration his health and his medical condition, his previous backup history, and multiple other parameters, there are a lot of tools which will give you the best plan. But in case there are certain additional things that your tool would do as far as a particular feature is concerned, it makes a lot of sense to go ahead and protect that feature. Wherein based on these 5 or 6 parameters like historical information, medical data, insurance, have they utilized the insurances or not, and based on all these data, if you can probably tell him of what are the kind of investments that he's looking forward to going forward. That could be kind of a functionality which would be appreciated and which would make your product differentiated. So that's probably the right way. So it completely depends on the startup, the business model that you have, the revenue generation schemes that you've developed for yourself, and so on and so forth.
Okay, I think we have answered almost all the questions now. So, Mr. Tarun, you can conclude from your end.
Perfect. Thank you so much, everyone, for joining in. And I'm available. My phone number is there on the screen, and my email ID is also there in case I can give any assistance. It was the first time that I was doing the webinar, so there were a couple of hiccups for me as well, talking to a virtual audience. So there were a couple of hiccups. I apologize for that. But in case there's anything that I can give assistance on, as far as any concepts are concerned, and if there are more specific issues, because if there are more specific issues that anybody would want to discuss, makes more sense and will give them more clarity as well. I think I'm done.
Thanks, Mr. Tarun, for your informative session on intellectual property and its growing significance to tech startups and IT companies. It was indeed an enlightening session. I would also like to thank our participants for their support in making this webinar a huge success. The recording of this webinar will be available on techgeek.com by tomorrow. The next session in TechGeek webinar series is happening Thursday, 9 February at 3 p.m. Topic for the webinar will be SQL Server Architecture. We will be having Mr. Venkat S. as our guest speaker. So see you all on Thursday. Thank you.